Good afternoon, everyone. Thank you all for being here today. It's a pleasure to welcome all of you to this Reflexões ao Cair da Tarde session of the Rui Cunha Foundation. Tonight's presentation is titled Unlawfulness and Liability, drawing from comparative law to clarify future court decisions. And it's my honor to introduce author, Professor Isabel Mouzinho de Figueiredo. Professor Figueiredo holds a PhD from the University of Lisbon and is currently assistant professor at the University of Law from the University of Macau. She's a lawyer with over 20 years experience in Portugal and has published legal research in Portuguese, German, English, Spanish, and Italian. The combination of rigorous scholarship and real legal practice gives her a particular authority in this matter we are discussing today. She speaks not only as someone who has studied the law and what we're going to talk, but also as someone who has been in the application of the law. Tonight's presentation addresses a question that goes to the very foundation of civil liability, whether the legal structure that was inherited from the 19th century, built upon physical harm, identifiable wrongdoers, and traditional injuries, is still in a world in which the harm is algorithmically driven, the cause is diffuse, and the entities are amongst the most powerful in the world. Does this traditional system applies? The recent US verdicts against Meta and Google are perhaps the most visible recent breakthrough that calls for a deeper reflection on a question that is not new and that the author has been studying for quite some time. The question at hand is a structural question. Our tort system, whether rooted in the German Civil Code or in the common law, were never designed for the scale and the visibility of digital harm. When corporations cause widespread injury through systems that are deliberately engineered for certain effects, the law struggles to even reply to the most basic of questions. What exactly is owed and to whom it is owed? Professor Figueiredo's answer, drawn from a comparative law perspective, is ambitious. She proposes a four-tier framework that could improve both civil and common law tradition and hopefully future-proof our tort system for these new and not managed at the time causes of harm. It is our pleasure to have her with us today. Professor, the floor is yours.
Oh, thank you so much. Thank you. This was a very, very kind introduction, and my topic is ambitious indeed. I hope I don't disappoint. My contribution, I hope, is just to bring some reflections and some food for thought and see how we can improve the existing law, not only in Macau legal system, but from a global perspective, learning from other legal systems. So, can we have, yes. Thank you. So, I will have a look at old liability approaches, and I want you to accompany me on this journey to see them under new scrutiny before new ways of inflicting harm in the 21st century, and see what we can learn from the past and how we can improve for the future. So, one of the first questions that would be provocative would be to know, is digital harm recoverable? This is not an easy question, and obviously it starts with the problem to know what exactly is digital harm. And you have so many ways of digital harm. In a way, we could differentiate, like with environmental law, you can have harm that is inflicted through the digital to classical legal positions, or we have a harm that is inflicted to digital goods, if we will. So just for illustration of the problem and of its extent, we have software that kills. This is real. You can maybe you've heard of the British Post Office scandals. and so many other instances. Or, for instance, if you have a medical robot that does the wrong incision, of course, you will be threatening life or body and property, reputation, business. So these are the classical legal goods that would be affected through the digital means. And then, of course, you have the new digital goods, which would be like the personal data, and so many things that can be done with it. The law is always lagging behind in helping enforce the new values. And also what we could call like the digital personality. Imagine for a moment whether you are a business or a person, that all of your passwords suddenly don't work. You don't have access to work, to leisure, to social contacts, or anything else for that matter, or chores, or banking, tax authorities, whatever. So this would be a very grave curtail of your identity and of your existence in the 21st century, which was not possible in the 18th century. Then you have new types of harm, such as the mental health condition of addiction, of not any. If we spend 5 minutes on social media per day, that is fine. But this is not the case when we have pathological addiction. And since the 1980s, you have the World Health Organization that is categorizing mental health and addiction as a harm per se. So it's not only addiction caused by opioids and other physical drugs, but also it is this Silicon Valley has been very open about how they want to intentionally cause addiction of all users to the screens. For little profit, they cause enormous harm. And here we have a very clear harm within the pathological addiction. And then, of course, mass manipulation or information. But here we will come back to this. Or when you have algorithms talking to each other and establishing the price for this person. They are adjusting the price on competitors towards your particular profile. Now, some people say that this is not a cartel, but this is obviously a cartel. Like you have automated contract formation, and here this is a way of automatic contract formation. So these existing rules that forbids unfair competition and forbid cartel can already be prepared for the future, but we need to acknowledge that this is effectively a contract. It's as simple as that. And then if you induce people into mistake, misrepresentation, or other kinds of exploitation of your need, this would be solved by other contractual law approaches. So digital harm goes far beyond the realm of traditional tort liability as such. Brief illustration. Now, we will start with existing tort models, some of its flaws, and then the proposal for better decisions for the future, in my view. So traditional tort models, they usually rely either on a general clause where you simply say neminem leder, don't harm anybody, don't harm others, or you can have a list of single torts where you say do not trespass, do not cause nuisance, and so forth. Let's have a brief look on some of the existing systems. So the Napoleon Code and Spanish Code that follows, they focus on the idea on the Roman idea of fault. So if there is, if you frown upon the conduct, then probably you will have to compensate. Italy, on the other hand, has a very similar approach, but focuses on the unfairness of the outcome. And this is, so here we focus on the conduct, and here we focus on the outcome objectively. Then in Portugal and Macau, which it's hard to read, but you know it by heart, we require an action that is unlawful with fault and that causes, there's a causal link that causes some harm. And we all know the examples that are usually used to illustrate these requirements. If all of them are met, then you have liability, and this is the rule that we know. Then we have the crux of the problem is to know when is a conduct unlawful. When exactly is it unlawful? And here we draw upon the panoptistic teachings of establishing two kinds of unlawfulness. One is the breach of a particular express safety regulation. So we focus on the conduct, on the harm. Or we can have the result of infringing a particular right. And if we do infringe this right, if this is the result, then irrespectively of the way to reach that result having been foreseen expressly by the legislator in a particular statute, you have liability and you need to compensate. So these are the two variations that are taught for unlawfulness. My question is, if a dog crosses a red light, can I run it over? So here my question, what I am asking is, there is a safety regulation. I comply with it. Do I have a duty of care that goes beyond the strict little rule that is in place to prevent that particular harm? The answer, I would hope, everybody agrees with me, is that I am not allowed to run it over, and if I do, I will have to pay damages for it. So what I mean with this is that lawmakers, lawyers often and judges oftentimes forget that the strict compliance with safety regulations does not exempt anybody from having to pay damages if they infringe an overarching duty of care of not causing harm to others. So the duty of care extends beyond the strict compliance. We can see other examples of this, like for instance, when IKEA recalls chests of drawers that fall onto little children because they're not fixed to the wall, they are complying. The chest of drawers are legal and they comply with all the safety regulations. But IKEA knows that it's killing children, and they realize that we should not kill children, so they recall the product. Another example is, of course, a medicine that was licensed but crippled many children and killed many people and caused immense. This was a scandal, and they paid too little, too late. But in theory, we have no doubt that even though it was licensed, they still need to pay compensation to the victims. Another example, which here in Macau, unfortunately we had a few cases, is that even jacuzzi builders are unfortunately not aware that jacuzzi filtration systems, they suck the water with such a power that sometimes strong, healthy adults drown because of this. So even though the regulations don't require safety measures, the owner and who installs is liable for these deaths because they could have prevented this. Now, my question is, when we say that they are liable and we do not fall back on and rely on a small little express statutory provision, where does this duty of care come from? So just to recap, compliance with safety regulation does not automatically exempt from full liability, and then we have another problem with right, which is the result. So the first problem is, what is a right? And notice here that when using English, I have a problem with right because in English they use claim and they use a different approach altogether to this reality. But Macau's and Portuguese-speaking lawyers, they will be familiar with the idea of a subjective right and the idea of an absolute right. Now, we define this. There are many books, many libraries on what constitutes a right, but effectively we could boil them down to the power to claim a conduct from somebody else or the legal permission to enjoy a particular benefit. But this doesn't say anything. I'm sorry to say. This is a circular notion where when you decide there is a right, you already decided that there should be compensation. And if you want to, okay, so everybody knows what property is, right? No, we don't. We have discussions, really ridiculous discussions in Germany about the case of a ship is fine, but the access is blocked, so the ship cannot be used. But I did not touch the ship. So do I have to compensate? Yes or no? huge discussion. Of course, nowadays we have established that yes, you are impeaching the use of the ship, so you have to compensate. But this was a discussion on what is property. Or in Spartan steel, or no, a similar case to Spartan steel in Germany, they were discussing if it is a physical harm if the temperature of the molten steel becomes cold and hardened. Of course, you need to reheat it to bring it back to the molten state. But this is a huge cost for the factory, and but you cannot compare it to I warmed a glass of water and the water is fine. I did not harm the water. So you cannot say, is temperature change an infringement to property, yes or no? You have to put it into context and see the bigger picture to see if compensation is due or not. And the same thing with eggs. The reason I put these two next side by side, these were cable cases, very similar to each other. And here the German courts decided no, there is no physical harm. And here there was no, the incubator was not warming the eggs died, didn't hatch, they perished. And the courts decided that this would be, yes, an infringement to property. Now, I have a friend who wrote a PhD on property in Portuguese, under Portuguese in the Portuguese legal system. And if you will, when you decide where property ends, you are deciding also the limits of the remedies, not only of liability, but also of enforcement and other equitable remedies, the English would say, like injunctions to prevent harm. So, to Germany. German law is very different from Macau law or Portuguese law. Can you spot the difference, maybe? The black letter rule law, it seems the same, but it is fundamentally different regarding unlawfulness. Because the German lawmakers from the 1800s, they did not want to slip into like the French courts that had too much liberty deciding liability. So they said, like, we are going to be scientific about this, and it's the legislator who tells the judges that only in these cases, when there's life, body, health, freedom, physical body, only then can there be damages. But now they knew they could not foresee everything, so they put their other non-relational rights, so other absolute rights. They did put this valve of safety there just because they were unsure, and happily so. So this restriction changes what would seem like a general clause into a listing of rights that's, whose infringement will bring about liability. Now, of course, this could not exist alone. If you limit liability only to absolute rights, this could not exist in a legal system. It would be too imperfect. So this has to be complemented also by the idea of intentional harm. You have to compensate. The German jurisdiction, 2 years after the entering in force of the German Civil Code, they started inventing frame rights, like personality frame rights or business frame rights, just to accommodate, to cover holes that were left open by this excessive listing of the German lawmaker. Then you also have the normas de proteção, so safety regulation, express statutory provisions that say if this conduct is unlawful, if this conduct is adopted, then you need to compensate. This is what they call in the US the negligence per se. Then of course you have specific torts scattered around all of the legal system, and the legislator is very diligent in foreseeing whenever there's an injustice. They say, okay, we need to enact a law to cover this this part, and then you have extra contractual liability coexists with contractual liability, and because extra contractual liability is so defective, the German lawmaker closed a door but opened many windows through contractual law. So contractual law is expanding to you would be surprised. Like nobody else can even see contractual law anymore. But the Germans say that it is like in culpa in contrahendo, and the so-called contract with protectional effects towards third parties. That these constructs are there to cover the flaws, and then they have this third-party loss, which, if you think about it, if somebody has a loss, they're not the third party, they're a second party, they're the victim. Like it only makes sense to say that they are third party because they do not have an absolute right, but they do have very clearly a loss, and they should be compensated immediately. In Portuguese law, in Macau law, we compensate them immediately without having to resort to these complex labyrinths. And then they have this general clause, which would be like the duties to secure the traffic, which means that if you dig a hole in the middle of the road, you need to secure it so that others don't fall in. And this is effectively, von Kammerer in the 1960s said that this would turn the whole of the German tort law into a general clause, which is what many still say that is not possible in German law. Anyway, and then you have other things. Comparing to common law. Common law has a listing. We only have very specific torts, like in old Roman law. But since 1932, amongst all of these torts, we have negligence. And negligence, if you take a tort law book, negligence occupies 2/3. And the others are just like one little chapter and not really very relevant. So negligence effectively took up a huge role in what is called the neighbor principle: don't harm others, don't harm your neighbor. And so this turns common law effectively into a general clause system, in my view. So to sum up negligence, we have the neighbor principle, we have the requirement of proximity, and we have the three-stage test from Caparo. But foreseeability is the first one. Here, the probability of causation is allied to the subjective predictability. We know this from the causational link, and we have similar theories that encompass these aspects. Proximity, there are very peculiar, bizarre discussions to know if this proximity is supposed to be in time and space, which in the 21st century is even more ridiculous. Of course, the proximity, and this is, Jane Stapleton rebuts this very clearly. She says it's a matter of legal imputability, and this is also in the book of Hart and Honoré about causation. It's a legal imputability and not exactly a physical causation or a proximity of time and space, which draws back to the idea of subjective predictability also. So, but if you look deeper, it is a slippery word, says Nolan. Proximity is a convenient shorthand for a relationship between two parties, which makes it fair and reasonable that one should owe the other a duty of care. This is what Lord Nichols says in the case Stoven and Wise. So, proximity is nothing. So, this we know what it is. Proximity, again, is an empty shell, an empty word. And the third requirement is that it should be fair, just, and reasonable. This is also called sometimes the policy concerns. And this is a blatant tautology, says Nolan. So again, we are taught since year one in law school that we should not say it's unfair. Like, we need to present better arguments. So fair, just, and reasonable is a general repository for a miscellaneous set of policy arguments, So it's nothing. Looking with a civil law background to the common law system, we realize with more clarity that we are packing uncertainties into other uncertainties. So whenever we say duty of care, what is it? Foreseeability and proximity. But what is proximity? Well, then we go into poetry, but not really. We don't really solve the problem with what Jane Stapleton calls a grand theory that solves all the cases. This is really not possible in damages law. Now, nobody really knows what the duty of care is, not 100%. So one of the questions that the British or the common law focuses on is who decides. So they think it should not be the legislator. Peter Kane, in his article Taking Disagreement Seriously, he advocates for this idea that judges should decide when damages should be awarded or not. And then you have Jane Stapleton refusing this idea of a grand theory. Now here we have the idea of Montesquieu, who decides, but we still need to know decides how, based on what, right? So Holmes in the 19th century said that the common law on tort is a chaos with a full index, which in the 21st century has the problem of data protection. We have all these names, and even as pedagogically as a law professor, like why should you teach all these cases that to a large extent are not very interesting, right? So can't we do better? Here we have this groundbreaking idea where it was not the legislator, it was not the judge, but it was the jury in the US who decided that digital addiction is a harm. And this is something that psychologists have known for a long time, and lawyers are still lagging behind or pretending to. There are many reasons why the US legislature does not acknowledge this very clearly, or the US judges, but I'm usually very skeptical and critical of the system of juries. I don't think it's fair that lay people should decide other people's lives, to die or to live, mainly. But here the system of jury was very welcome and broke through many of these old barriers. Now, in the US, because of the of course, many states, but we have the restatement, and the restatement draws back on the contributions of continental European scholars, and so they bring a theoretical framework that says when you have a duty that is breached, that has causation, produces damage, then we have liability. We recognize this as continental civil lawyers. Now, how do these models help us decide digital harm? So Germany, common law, and USA still have this huge problem of being scared of what they call pure economic loss. And pure economic loss, it took me a long time to study and realize what they are, but it is essentially non-physical harm. If it's not a scratch on the body that you can see, if it's not a scratch on property that you can see, then common law and German law are very wary to acknowledge a duty to compensate. Now, this has obviously many flaws. Let's have a short look before going into the proposal. Amongst many flaws, you have the absurdity of third-party laws, the definition of property as an indirect way to decide liability or not. For instance, the pharmaceutical risk. Should somebody who is sick, are they entitled to be healthy? Or is the loss of health a risk of life that they should accept in part, right? So these are a few. Let's have a brief look at the financial regulator and the cable cases and some of the physical cases, just to see how the traditional approach is wrong and how this could be decided better. Imagine you have two hotels side by side. You have an oil spill, so tourists don't come. In one case, the oil is on the hotel's property. So German law and common law will say, well, then the hotel can recover everything, lost profit, you name it. But if the oil spill does not touch the hotel, and the hotel is in appearance clean, then they cannot recover anything. Now, this is wrong. These two cases are too similar for such a different outcome altogether. Another example for the cable cases is very similar, or it's similar if I draw these houses. So Here the idea would be, if the cable that supplies internet connection, optical fiber or gas or electricity or water, if the cable is severed and the cable belongs to the factory, then the factory can recover all the lost profits. But if it does not belong to the factory, then they cannot recover anything because it's considered pure economic loss. So if you ask me, both decisions are wrong. So, but what I mean to say is that let's not focus on the physical. Let us focus on what really matters. So you can see the chaos in German case law. That's where in some cases there is compensation and others not. Even internationally, you have some cases the compensation is denied, where factories have to shut down because the cable is severed, or in others the compensation is granted. So which one is it? What's the right solution? If you read the decisions of the German court decisions, you would think that the contractors should abolish machines altogether, and they should be like archaeologists trying to discover the little cables, which obviously is an absurd employment of human resources. I think that the best solution for these cases is obviously that a factory should not rely excessively on one little cable. If they produce this big hub that makes a lot of money that they don't share with others, then they should themselves have a generator or any other solution or an insurance, but they should internalize their own excessive wealth and that they should not shove upon other people. So the business should bear most of the loss. And then, of course, you have the infrastructure manager. They can put protection. They can protect not only physically against machines, but also with warnings and the placement. They can make it much harder to sever the conducts. And then, of course, you should have, if I want to dig in my garden, there should be a central authority where I go and I ask, can I dig here? And they say, no, there's a dangerous pipe there, so I dig somewhere else. This would be, I think, very simple solution for everybody. And then if everybody does their share and the contractor still manages to harm the conduct, well, then I agree he should pay for his share. So what decides who pays what is not the physical harm. It's an entirely new set of considerations. So the business is the cheapest avoider and the main beneficiary of the risk, and they created the risk in the first place. The infrastructure manager could prevent the harm at the source for everybody, and the central planning is, again, cheapest avoider, and then, yes, the contractor has a duty of care. Another example, liability of financial regulator. Big conundrum, yes or no? Should they pay or should they not pay? Now, the traditional approach of tort law sees the financial regulator as a tortfeasor that causes harm to a victim. But this makes judges cry because both decisions are wrong. So the approach that I suggest is that the financial regulator is not the main harm inflictor. If you don't mind, so here you have like the company who's doing the wrongdoing, and the financial regulator is somebody who needs to prevent the harm towards the public. So they are not getting rich with this situation. They are only preventing the harm. So they should definitely not pay 100%. They should pay maybe 1%, 10%, I don't know. This would now depend on the cases. I have an article on this where I discriminate these situations. So and this is one paradigm, harm prevention. The role of harm prevention of the financial regulator is very different from the situation where the financial regulator goes and kills the messenger. In this instance, BaFin was persecuting the journalists of Financial Times who exposed that Wirecard was a fraud. Now here, I think BaFin should pay 100% of all the loss that they caused to those who did BaFin's job. So very different cases. Harm prevention, pay a percentage. Harm infliction, pay 100%. I'm going to skip pharmaceutical risk because of time. So, but in short, pure economic loss, loss exclusion, recoverability should not be excluded based on the physicality of it or similar, but on other underlying causes. So, when the lawmaker is drawing these very neat lines, and that the Germans take very seriously with very sharp borders, what is the big monster that they are afraid of? So usually these are the floodgates that keep liability not being unlimited but in check. So we have property and person as the main recoverable harm. And then we have the good reasons, the reasons that justify that this should be the limit. And now we can have look at well, any of these cases are arguments to keep the floodgates on this idea of person and property and similar. But and one of the main cases that I want to highlight is the idea of if a car runs over a person that has very profitable contracts, of course the car should not, the driver should not compensate the high-paying contracts of that pedestrian. The compensation should be very similar if you are an expensive CEO, expensive football player, an expensive opera singer, or you are just a regular person without these monetizations in contract. So these are the good reasons, these are good arguments to keep the floodgates where they are. Now we have the cases that say that this is wrong and this is absurd to establish the floodgates there. And here you have again the idea of a symbolic scratch, the third-party loss, how the absurd solution for regulators, auditors, police, or the excessive difference between contract and tort or extra-contractual liability, or the liability of rating agencies and the digital economy. Because remember that 100 years ago we were all very much an agricultural and industrial societies. Our world, our wealth, our life has moved online, and so the law must be brought online with it. So if you notice, the images that I chose are these clusters. So around one example, we have similar cases. And analogy can help us bring them together and help, if you solve one exemplary case, this helps us decide the others with a similar solution, which brings fairness to the whole picture. And of course, you don't only have like black and white or green and red, but you also have brown and many other colors and many other dimensions that the law should consider. But I do think that we need paradigms, we need these examples that make it very clear for us what the solution is. So when I say we don't know what the right is, right, the circular examples, the circular definitions, but just like a dictionary will tell you what a bottle means by saying what it is, what it's not, and examples, right? And for the law, it's the same thing. We need to say what it is, what it's not, and examples. And these examples, like the definition of a right, doesn't help us much. But the examples that are given, and the descriptions that are given, and the lines that are drawn by scholarship and by case law, these paradigms help us keep justice in place. So what is the solution that I propose? After so many problems, is there a solution? I suggest that we bring together these two approaches, which I think is already being done, which is have a principled unity, a theory, together with illustrated by the cluster of paradigms. So we need these two approaches, and this effectively shows that common law and civil continental European law are not that different. We both do this. And to help understand the theoretical unity, I put forth this idea of a balanced test. I think that judges hitherto have been relying on these criteria, but not always openly. So the first one, of course, is foreseeability of the loss. We have that in both legal traditions. But then we have the cheapest avoider, which the common law expressly relies on, but we do not, and we should. And then also we have the idea of greater damage. The extent of damage, be it in likelihood or extent, this creates a greater duty of care. And then we have, and this for me is what I find is the most innovative part that I contribute, is that we should look at who is gaining from the situation. Like, if the factory is getting rich, so they should keep most of the damage. If the person well, other examples. So who benefits most from the situation? Not only monetarily, they should also bear most of the risk. We know this from strict liability, and also the idea of what we call the liability for sacrifice. So when it's legal to inflict harm to save some greater good, then whoever has their goods saved, they need to pay whoever was harmed. And then, of course, the willingness to create risk. So if somebody decides to bring about the whole situation, so they should have a greater duty of care. And in the case of prevention of damage, if somebody, some third party, is the auditor, the inspector, the police, the regulating authority, if their role is to prevent the damage, let's see if they receive a higher pay or gain a greater profit, or if they have more means available to such an end. If so, they have a greater duty of care. So these are but a few, not a closed list. I find these are very relevant, and understanding this suddenly brings light, I find, to many situations that otherwise don't make any sense in tort law. So taking a step back, I find that liability or risk allocation, or sorry, harm allocation is done based on fault, risk, enrichment, and non-compliance. So here you have contractual law, or the violation of the law. Enrichment is whoever benefits, and if the situation is based on all of them, so we are in the center, the compensation should be high. But if we are in the margins of these scopes, then compensation should maybe be lower. Excuse me. So my proposal is a 4-tier proposal. We start with the existing system, or if you are from the common law, the duty of care. We start with the duty of care just as we have it now, and then we draw on this balance test for a theoretical guidance and uniformity. So the foreseeability, the cheapest avoider, and then the examples, the paradigms. And finally, some typical arguments that are very pertinent for typical situations, and they make sense. If we have time, I will explain that. So my proposal is keeping what we have now, but adding this balance test, illustrating with paradigms and the arguments. Let me explain, because so what is a balance test? When we learn the law, we usually are trained to see that if there is an act unlawful, there's fault and it causes a harm. So we need all of these requisites, otherwise there's no liability. This is how it is taught. This is the fixed system. We need all of them. A balance test is different. We have these elements, but we don't need all of the elements always present. So if we, in my system, we have 6 elements. If one of them is missing, it doesn't matter if the other one is heavy enough to carry the weight of all of them. So balance test is, just to give you an example, I often struggled when I was thinking about tort liability. I was often struggle like, yes, we do need foreseeability, otherwise no compensation. But then I think of an example given by Professor Gomes da Silva, which is, imagine somebody goes past the house and throws a stone into the house. And in the house, unbeknownst to him, there is a very expensive antiquity, a vase from the Ming Dynasty. He couldn't have known. It was completely unforeseeable and beyond the expectable framework of any foreseeability that there could be such a treasure there before he threw the stone. But we still agree it was not foreseeable, but you have to pay. Why? Well, there's the willingness to create the risk. Like, why would you throw the stone? You're throwing the stone for no good reason, right? So these things, you don't have foreseeability, but you have other elements that make you decide clearly you need to pay. So my proposal is not destroying the existing systems, but bringing them together by adding this balance test. We need tort liability books, accident law books, where we explore paradigms and we say, in this case, this is the solution, with concrete decisions. Law professors love to make like grand declarations without helping the decision maker, the judge, to say, how much am I going to award in damages? So for the new types of digital harm, I think we, particularly by when the big data or the big Meta and so forth, when they are creating addiction intentionally, they are, for a very little enrichment, they are causing a huge harm, and with because they decide to do so for their own benefit. So I think it's a no-brainer that they should obviously compensate. Maybe not. I mean, I spend more time on social media than I should. I don't think I'm entitled to a great deal of a compensation. But if my usage were to be pathological, and there are many instances where it is, then maybe it is pathological. But if it were to be worse, to worsen, I would definitely have an entitlement to compensation. And I think I've overstretched my time. So thank you for those who remain for your attention.
Thank you, Professor. Yeah. I think we just heard a very rare thing, which is a legal view with a very practical consequence extracted from the legal view. And not only the legal doctrine being discussed. Several things appear very evident, but two appear very important, which is, first of all, it appears like the old system, let's call it this way to keep it short, is unable to, the framework is unable to adequately solve the current problems we have, which are probably not current. Most of the examples you give are not exactly new. Some of them dated to the 19th century. And the second, that a proposal that merges different approaches, continental, common law, and a new view, appearance, structure on the balance test, the paradigm cases, and the policy arguments appears to give us a solution for it going forward. I would like to give the floor time if they have any questions that they would like to pose for what we just heard. Feel free at any time to ask. In the meantime, I will begin with a question that I think many of us ask ourselves when we hear what you just said, and that goes to the heart of the proposal we just made. Traditional law, especially continental law, have very specific requisites. In particularly, it goes among the three principles that we can see because of what you said. Risk liability is an exception, it's not a rule. Unjust enrichment is the last resort. And compensable harm, I don't know exactly the term in English, is mostly of the cases limited to absolute rights, with very limited exceptions given in the law. Your framework appears to challenge these basic elements of the three elements being simultaneously there. If risk approach, which in some of the cases appear to be the case of what you just said, becomes the norm, if the unjustifiable enrichment becomes no longer a second step, but something to consider in liability, and harm extends We saw pure economical losses. We saw mental losses that might be not only physical harm but also social harm, social consequences. Are we not risking creating a system of total chaos and total liability and unlimited liability that goes far beyond our current scheme and current understanding of it?
Thank you for that question. It's a very, indeed, I think that strict liability should not be exceptional. So we should understand liability rules as a whole, and so who benefits from the risk should pay for it. You might argue that in the existing law of Macau now, we have the presumption of fault regarding somebody who's using for so-called dangerous activities. This effectively translates in practice already in an almost liability, a general clause for strict liability. And I agree that it is so, and it should be so. So, because if you have somebody that creates the risk and benefits from it, why should other people have to put up with their benefits and be collateral damage? Now, I am not. I know that I am pulling down barriers and floodgates, if you will, but I am complementing the black holes of our current system. I am complementing them with what I find. I'm clarifying how we are deciding now, but we don't admit that this is what effectively we are doing. And regarding the argument that now we have no limits and all the compensation is completely limitless, and I have two things to say. So one of the legal systems where damages are known to be most arbitrary and excessive is the US. And they have this idea, they still stand by this idea that pure economic loss should not be compensated. So that is not the problem. This is not the limit that is the problem. It's in a different front. And the other one is that paradigms, when we say here you compensate, the argument usually is, oh, but there might be a slippery slope and then everything is compensatable. But my argument is that you have clusters of paradigms where you say here you compensate and here you don't. So this could be a two-side slippery slope that helps you understand what should not. This is why I was talking about the opera singer or the rich CEO that is hit by a car. Here you should not compensate. And based on this example, you would be amazed how far-reaching the analogy of this example is to suppress claims, the gold-digging claims, excessive claims of liability. Another thing that I didn't say, but it's there in what I write very often, is the idea of proportionality. You have always to consider proportionality in various perspectives, and proportionality helps you to eliminate this fallacy of all or nothing. And when you force the judge to decide financial regulator needs to pay billions or nothing, he won't know how to decide because you're forcing him to decide between wrong and wrong, when the right decision is he should pay 1% to this and this in this case, right? So this is the suggestion that I bring, and that I find that is that if we admit to this, and if our textbooks explain this, we can have greater predictability of court decisions and more fairness overall.
I don't know if we have any questions. Not yet. Yes, please.
Thank you for your explanation. I will try to address something that it is connected with this, to my understanding, is the use of AI, and specifically on healthcare. Is something that we know everything about this one. The news are coming out more and more. The doctors, the professionals use this more and more, and is very good, of course, but it has the other face of the coin. And the problem is on the malpractice law, okay? And it is bound to the article that we have in Macau, the 477, that is a fault system, okay? What about these situations that when we use algorithms, okay, AI, that have a different kind of responsibility, of course, the companies that use that, they generate a lot of millions, how we can cope with this situation to change the law from a fault system to probably a non-fault system regarding the companies that we are addressing. I don't know if I was clear.
Let me try and comment, and then you will tell me.
Okay.
So if I don't think that when the black letter law says fault, we need to interpret this in a modern view where we don't consider this like the medieval sin idea, right? Like that you did something wrong. What judges do today is that, even if they don't say so, is that if somebody is benefiting from the situation, the judges automatically will say like, this is fault. But even if there is no fault, like if in the original term of you don't think the conduct is admissible, right? So what we are doing now already is regarding the willingness to create the risk and the fact that somebody is benefiting from the risk. We already consider that as being fault. I had something else to say, but I forgot. Can you please help me?
My problem is that most of the times when we are using AI, is that the fault is not from the health professional. The fault usually should be bear by the company that produce, the system that makes the evaluation, the analysis, the exams that analyze this one. And when they give the information to the professional, the health professional, usually, as it should be, they trust the results. Okay? Where is the relationship in here? The fault is from the professional that should have a due care to check if this is the correct evaluation, or it should be bear by the company that produce the AI model that make this evaluation by itself. That's my main concern.
I'm missing here a lot of things here because I know this is not an easy question, but let me start by this. We have one of the main dangers of AI is that we over rely on it. So and we will all do it because you ask one question to AI, it replies correctly. You ask 10,000 questions and it replies correctly, and you stopped questioning the answers. And this over-reliance is not a good thing. We need to retain critical thinking, and we need to retain some self-responsibility. Everybody, not only doctors when using AI, but everybody, and to the extent possible, of course, because the AI does things that humans cannot. There is a lot of research going on also on the idea of how to minimize when is AI admissible, when it is safer than the human. But then how do you assess this, it being safer? Is it in the number of accidents, or is it in the gravity of the accidents? Or, you know, there are a lot of ways, those who study probability and statistics, they know that these comparisons, when oversimplified, they are not very easy to make these judgments. But going back to basic tort law, all the players should do their best to prevent harm. With AI, we have, of course, the big problem that we don't know who does what when, and why. So, and this exceeds, like, this goes beyond the problem of tort law per se, or on how to decide. This goes to the problem of the digital world is now the far west, where there is no, it's very difficult to keep proof of what's happening. And also with AI, you don't know who is training this AI, and many conflicts of interest are not disclosed. So you have people making money on AI on ways that we don't dream of. So my solution for AI in general, including in healthcare, is that because there is this opacity, this black box effect, and this impossibility of proving anything, this could be solved with blockchain technology worldwide, but that's a different discussion. We're not there yet. So right now, I think the best solution, the best approach to solve this would be that we know AI is a product that many are investing heavily in, and they are investing not out of the kindness of their hearts. They want to extract profit from it. They want hard money from it. So the approach should be more like money laundering. We should have a look at who gets what money, and they should explain, why did you get this money? And if they cannot explain with a just cause, causa contractus, then they should be forced to disgorge it. Because if these medical AIs, they are working for pharmaceuticals or so many other ways to make money, and the medical world is, particularly in the US, it's systematic usury, if you will. So because people are always blackmailed to death to pay everything that they have for their health. So this is a particular sensitive area where regulators should step up and protect the public, I find. There are more questions to this, of course, and of course you have the EU Liability Act, directive that is still in proposal. The EU AI Act is really funny. It says, high risk is forbidden. How do you enforce it? This reminds me of this German politician that was asked, like, how do you monitor corruption in your jurisdiction? He said, like, corruption? It's forbidden here. The EU says, high risk, it's forbidden in Europe. It's ridiculous. Sorry. I'm sure there are many more answers to your questions. I know I was beating around the bush. Would you like to add something?
So picking up on the question, I don't remember if it was a couple of months or a couple of weeks ago, there was a piece of news of an AI hospital being built in mainland China. If memory serves me right, the whole process of diagnosis, well, the whole process from admittance until pre-treatment is all AI handled. From deciding which, based on the complaints, which exam should be held, and based on the results, which extra exam should be held, and based on whatever results, which doctor to recommend, which whatever treatment the AI would consider feasible. I would guess in the question being made that if we just use a pure current system, okay, based on the very old tort law system, we would go and say, well, if the AI messed it up, the fault is at the doctor. The doctor has a duty, because I'm with the doctor, is an instrument. Because the question is not so different from what is happening right now with law. So we had a judge in Portugal who did an AI court decision, who completely fabricated court decisions that didn't happen. We had lawyers who submitted claims, AI generated, with also court decisions that didn't happen. How would we handle this specifically on the current system and on the proposal you bring? Because in Portugal, the solution was send the decision back and have the judge redo the decision. Probably some disciplinary consequences, but there was, hopefully, but there was no immediate tort compensation given to the parties. In US, there was a similar case, and the solution was, I don't know how they regulate in US, honestly, but I know that the solution was force everybody that uses AI in the preparation of a court decision or a claim or anything to disclose exactly what was used. And if there is any mistake, in US, the lawyers are liable for it. There's currently a case, no decision yet, exactly based on this. how would we solve it based on our traditional act, unlawful, fault, causation, and harm? How would we solve it? Would we go saying more likely
No.
it's not caused by the AI? Would we just blame the individual?
Now you put me in a very difficult situation because this is the system that I believe in and that I think is already in force to a large extent, and you force me to think like a tradition, like more like those I disagree with.
And that's what I hope to see the difference between what you're tracking to us and what would be the situation.
So, well, if you going back to the doctor, you might think that if everything is decided by AI and everything is presented to the doctor, basically you only have to tick one box like yes or no, and that's all of his duty. There might be the case to argue that he was not at fault, right? Like in this is another very funny idiosyncrasy of our system, where you explain unlawfulness is the objective infringement of the whole legal system, but then fault is the subjective. And when you think like, how can they be in contradiction with each other? And if I after some reflection, I thought like, okay, basically you have four situations where there is unlawfulness and not fault, and this could be one of the cases where you could say the doctor's lawyers could argue that he did not know, and did he have a duty to know, right? So this would be maybe one of the approaches, but yes, I find that because I hope humanity does not over-rely on AI. I hope that we should keep the end users to some reasonable extent liable and accountable for their own actions. And this is very important. Let me just introduce this other situations. Nowadays, and this is a real problem in many societies, people, if they have a legal problem, they don't go and ask a professional anymore. They ask AI. And they trust AI. And you think there's no harm in that. It makes justice more accessible and much faster, which in itself is a huge bonus. And this is great. But if you think what we are doing, we are yielding the power to legislate, to decide, to enforce to these unknown people who are manipulating us with the AI investment for their own reasons, with their own algorithms that we cannot grasp. So this is the power that by over relying we are giving to the AI is excessive.
I don't disagree. But for example, in your balance test, also brings a lot of power for the decision makers, who should we also be able to a certain extent, not allow. Traditionally, we talk about the German law, which is the idea is we don't want the judges or the decision makers to have a lot of power in saying what should be and what should not be subject to a tort system. With your proposal, we open the door exactly for this. In a system as the German one, how would this work?
So the German scholars think that the judges don't have this power, but of course they have. It's impossible not to. As soon as 1902, in a cable case, one of the Reichsgerichte, then they decided that there was this right to an instituted and established business operation. Like, what is this? This is inventing new rights, just because in this case you needed to compensate, and the rigidity of the lawmaker didn't allow for this solution.
Might be unfair, but it's still it raises the question I raised in the beginning, which is, are we making the whole system less predictable and too much less predictable? How can, for example, in a balance test, how does a company that wants to produce something, either AI, digital, or otherwise, how would they?
Okay, let me. So, as I said, the balance test is not here to replace the existing system, but to complement it where it doesn't reach. Let me give you another example of something that a paradox that German traditionalists are completely unable to explain. So if you have the unlawfulness of an act of causation, how do you explain that if I drive a car, there's 100% probability that I cause pollution, and pollution is a harm? Why is driving a car legal? On the other hand, if I drive a car, I cause the risk of causing accident. Why is driving the car again legal? And the accident can kill people. Why is it legal to go about and create? The answer, of course, is because driving a car helps humanity and helps the economy. So there is benefits not only for those who use it, but for everybody, for society as a whole. So these are you make a proportionality evaluation assessment, and you find that on the whole it is worth this risk and this 100% certain damage of pollution, because it makes our life easier, and it outweighs clearly the risks and the harms.
And we replicate it for the digital world as a whole.
Yes.
So just a closing question, if no one has anything else, quantifying the harm on a situation such as, to be specific on what we talk, digital addiction, a life diminished, opportunities lost, human happiness, and so on, is something that the courts are brought much more often today to discuss. In your view, is there any legal system anywhere that right now already develops the tools to handle this? And I ask because I took 15 minutes today to check at least one of the court decisions from the US, and it didn't create anything other from an other perspective. What it did was basically say your product has a fault, is a defective product, hence you are liable for the consequence of the defective product. Is this the way going forward, or do we have other tools, and such as yours? Any courts trying other tools and not old ones?
Right. So I think these questions are definitely connected, but I think that to complement, this is just the side of when do you have to compensate, and then you have the side, of course, like how much. Right? Like how much in specifically, and the law has evolved from the idea that we cannot pay for pain to yes, we can pay for pain, and how much is pain worth, right? Like and suddenly with case law, like with examples, you would also almost create like a table. And I think that the legislature might help by putting such a table forth, but I definitely don't think that the rich CEO should be paid much more than somebody else who doesn't have these profitable contracts, precisely because I think that the harm that is being inflicted should not perpetuate social inequalities that are already there. So one of the things that today, if you cause a car accident, you have to pay somebody's wages while they're in hospital. And here you have, it's not fair that you have to pay a lot if you hit somebody who earns a lot, and you have to pay little to somebody who earns little. This is, if you will, it's reinforcing and perpetuating social inequalities. But it's a system that we have, and on the whole, it's not too bad. But you compensate that and not beyond. Now, I find that you can make up these tables for non-pecuniary losses. So this is not uncharted territory for experienced lawyers.
I guess that's it for today. I thank Professor Figueiredo for being here. Thank you to all who are here present and those who listen to us on the digital platforms. I think we need another continuance for the discussion today, and certainly they will have a chance to.
Thank you
so
very
much.
Thank you. Thank you.